Monsieur l'ambassadeur, monsieur le Judge Advocate General du Royaume-Uni, messieurs les procureurs généraux, mon général, mesdames et messieurs les avocats généraux, messieurs les directeurs, chers collègues universitaires, professeurs et maîtres de conférences, mesdames et messieurs, je suis ravi de vous accueillir en ce lieu prestigieux, ce haut lieu de l'ordre judiciaire français, la Cour de cassation, sous les auspices des grands princes codificateurs de l'histoire de France, Justinien, Napoléon, Charlemagne, Saint-Louis. Et je suis ravi de lancer très brièvement cette deuxième journée de l'International Military Justice Forum. La journée d'hier était consacrée à l'étude de l'histoire de la justice militaire et à l'histoire comparée de la justice militaire. Cette seconde journée sera consacrée au droit contemporain, au droit d'aujourd'hui et aussi à l'étude et l'analyse du droit tel qu'il pourrait être dans un avenir proche. Je cède immédiatement la parole au président de la séance de ce matin, M. Ronan Douaré, qui est le directeur général de l'enseignement et de la recherche à l'Académie militaire de Saint-Cyr-Couët-Quidan. Merci beaucoup, je vous souhaite une très belle journée.
Merci, cher Gwenaël. Monsieur l'ambassadeur, monsieur le juge avocat général du Royaume-Uni, messieurs les procureurs généraux, mon général, mesdames et messieurs les avocats généraux, monsieur le directeur du CREC Saint-Cyr, mesdames et messieurs les professeurs, mesdames et messieurs les officiers, mesdames et messieurs. L'appel à communication des organisateurs pour ce premier forum a connu, vous le savez, un grand succès, ce qui leur a permis de réunir de nombreux intervenants, ce qui témoigne également d'approches variées de notre thématique, avec, nous le verrons, des tendances de fond. Le général de Courrèges, qui commande l'Académie militaire de Saint-Cyr-Couët-Quidan, qui était présente hier, m'a chargé de vous redire tout le plaisir qu'il avait à travailler avec la Cour de cassation pour cette thématique. Nous allons nous intéresser aujourd'hui, après l'approche historique abordée hier qui intégrait déjà une démarche de droit comparé, à plusieurs panels et à différentes situations. Nous verrons après une pause la situation notamment de l'Australie. Et dans un premier temps, nous allons nous intéresser aux situations du Danemark, du Royaume-Uni, mais également une comparaison entre Portugal, Brésil et l'Angola. Je vais vous présenter nos trois premiers intervenants que je salue et je laisserai tour à tour la parole. Il y aura des questions-réponses, comme traditionnellement, mais à la fin des deux premiers panels. Voilà, je suis très heureux d'accueillir tout d'abord M. Lars Stensborg, qui est procureur militaire général du Danemark, qui a occupé différentes fonctions au ministère de la Défense, mais aussi au ministère de la Justice, ainsi qu'à la direction de l'International Society for Military Law and the Law on War, mais qui est membre également du réseau des procureurs militaires de l'Association internationale des procureurs. Monsieur Alan Lange, monsieur le juge avocat général du Royaume-Uni, c'est un plaisir de vous recevoir. Quelques mots également de présentation rapidement de votre carrière, une carrière prestigieuse. Vous avez rejoint le Royal Navy en 1979, que vous avez servi pendant de nombreuses années, et en particulier pendant la Première Guerre du Golfe, avant de poursuivre votre carrière comme avocat. Et puis, vous avez rejoint la magistrature en qualité de juge avocat général. Vous êtes un membre actif du Commonwealth Magistrates and Judge Association, mais également du Commonwealth Lawyers Association. Et enfin, nous entendrons le professeur Mario Monte, qui est professeur à la Law School of the University of Minho, au Portugal, qui est auteur de nombreuses publications, articles et communications sur la justice militaire. Voilà. Monsieur le procureur militaire général du Danemark, je vous laisse la parole pour une vingtaine de minutes à peu près.
Merci. Distingués mesdames et messieurs, chers collègues et membres du comité, c'est avec grand plaisir que j'ai l'honneur de vous présenter les questions actuelles et émergentes en matière de la justice militaire au Danemark. Avant de commencer ma présentation, je tiens de remercier les membres du comité d'avoir arrangé cette importante conférence. Plus que jamais, dans notre monde globalisé où il y a de plus en plus de discussions à propos des systèmes de justice militaire, on ne peut sous-estimer l'importance de l'échange d'expérience et d'informations avec d'autres juridictions. And now, for the sake of the French, I will go into English. Thank you. I've been recently attending a conference in Oslo on the abolition of the Norwegian military justice system. So I'll just give you a very fast state of play in the other Nordic countries. In Sweden, this happened years ago, and in Finland, It is a civilian system that deals with military crimes with some specialization. So my presentation would fall in two parts, a brief presentation of our system, and then discussion of some contemporary issues or challenges, if you like. I'll start with a brief account of the evolution of Danish military justice. It was forged in early modern times, as historians call them, after the Peace Treaty of Westphalia more than 350 years ago. The system was further developed, of course, and reformed in the following centuries. I will just touch upon two landmark reforms that might be of relevance for the discussion today, the 1919 and the 2005 reforms. The first one, the 1919 justice reform, changed the system quite a lot. It abolished the inquisitorial system, separated the courts from the executive, and abolished the courts-martial. Although it was argued that special jurisdiction for parts of society would be inconsistent with the principles of equality of the law, the military justice system, I just call it the MJS afterwards, was maintained as a commander-centric system due to the need to secure order and discipline in the military. The 2005 reform was a comprehensive reform that was adopted by Parliament and came into effect on 1st January 2006. The military justice system, the MJS, was maintained as a means to support the operational effectiveness, discipline, and order, in particular with a view to the current international operations. Further, the reform entailed a fundamental change, namely that the competences of the military and the prosecution were separated. The Military Prosecution Service, I will call it the MPS, is now the only competent authority to handle military criminal cases, whereas the chain of command, as the competent body to deal with minor offenses and lesser degrees of negligence in a framework of summary proceedings characterized by a speedy, non-judicial administrative process. This was the system, and now I just look to how it works today. The Danish military criminal justice system is a separate system, but it is an integral part of the general criminal justice system and abides with its fundamental principles of justice governed by the Administration of Justice Act. As the European Convention on Human Rights was incorporated in 1992, jurisprudence from Strasbourg obviously has had an impact on the system. So the next item I'll touch upon is the criminal jurisdiction, the military criminal jurisdiction. Let's take the first part, the territorial jurisdiction entails to crimes committed within and outside the territory. The personal jurisdiction encompasses military personnel in active service, not civilians. During armed conflicts, the jurisdiction extends to anyone that are either serving in the armed forces, including civilians, or committing of an offense against the efficiency of the military forces, including foreign citizens, POWs, and that. The subject matter might differ as well from some systems. It, of course, entails violations to the military penal code. There's the classical offenses that are not reflected in the civilian criminal code, such as desertion, insubordination, neglect of duty, and as well as a set of war articles. Further on, we have the ordinary criminal offenses, such as assault, theft, allegations of sexual abuse, manslaughter, and rape. These are comprised as well if there's a military nexus, as this would have an impact on the service. I'll move on to the three stages in the procedural chain. Start with the investigations and prosecutions. Here we have a configuration that differs from other MJS. It's the military prosecution service that is the only competent authority to both investigate and prosecute military criminal cases, guided by the fundamental principles of objectivity set out in the Administration of Justice Act. Therefore, we have prosecutors and investigators under the same roof, which facilitates an efficient and smooth cooperation, quality and legality control in the pre-trial phase, with the prosecutor directing the investigations. This is, in fact, the same system we had in civilian system as well. We are able to launch investigation ex officio, and we don't have to rely on referral from other bodies. But of course, in reality, the majority of the 700 to 800 cases we open every year, they are mainly reported from military authorities, including military police, but also individuals, including from whistleblowers. We form part of the military of defense community, the MOD community, which facilitates easy liaison with the ministry, the military commanders, and other agencies within the ministry. At the same time, we are independent from the military chain of command and subordinate only to the Minister of Defense, in the same way as a civilian prosecution service, I will call them CPS, is subordinate to the Minister of Justice. I'll come back to this later on. Military authorities, as well as the national police, must assist us when we request it. So I'll just give a few notions on the cooperation with the police and the civilian prosecution service, the CPS. We have excellent relationships, both with the police and the prosecution service, and have the possibility to, when we have some very special cases, to have the national police conducting interviews. We had an incident some years ago where we had to interview the minister as a witness, and we asked the national police to do that, and it worked quite well. The relations to the CPS are informal and efficient, and we have regular meetings with the Director of Public Prosecutions and other officers in that service. Just a short line on the courts. I've already described it, but the military cases, as I mentioned, are heard by the ordinary courts, and the procedural rules follow those applied in civilian criminal cases, with a few exceptions due to the nature of military service. This is the platform for the contemporary issues I'm going to discuss. Keen observers of global military justice would agree that there occasionally has been eruptions of distrust with the MDAS, spurred by specific incidents or cases. As a public authority with the sole responsibility for the conduct of military criminal cases, we have often been in the limelight. In particular, during the operations in Iraq and Afghanistan, inter alia, it was argued that the military investigates itself. So I'll look into some of the critique we have seen in Denmark as well as in other countries. There's, of course, the general critique of the military justice systems. The frequent question that would be asked is, what is the purpose of a specific military justice system? And what is so special about the military that it needs its own military jurisdiction? And the answer is, in our view, that the armed forces are unique, as they have the power to use force to enforce government policy, and the rationale for a specific military justice system is to support the readiness and operational effectiveness through maintaining discipline. The MJS is a strict regime. Petty crimes are considered much more serious than similar offenses in civilian life. This is sometimes hard for soldiers to understand, as they are, I quote, as just civilians in uniform. Obviously, there's a divide between the one jurisdiction approach and the MJS approach, as we've seen in Norway, for instance. The former usually underlines the importance of investigators and prosecutors being experts in their field, and that identical cases should be dealt with in the same way. One could, of course, not disagree with the prerequisite of these elements, but there are alternatives to scrapping the MJS to achieve these goals. I'll point at another point that has been under critique. That's the specific types of crimes. Last week or so, the newly appointed Minister of Defense in Canada announced that allegations of sexual offenses would be handled outside the Canadian Armed Forces and the military justice system. A similar discussion seems to pop up in other countries. We have not seen this yet, but we stay alert, as media and political interest may suddenly accelerate. And apparently a TV channel is presently preparing a program on the subject. Then we have critique on the case processing time, the expedience. This is, of course, a concern for the military chain of command, and this is a great concern for us as well. And there's a little comfort in the fact that the military criminal cases are in general processed faster than in the civilian system. The most important issue I'll touch upon would be the independence of the system. The separation of power is obviously a cornerstone in government in a democratic society based on the rule of law. In recent years, we have seen independence of judicial systems challenged in some countries. The independence of the prosecution, whether military or civilian, constitutes a cornerstone of justice as well. Independence entails that the prosecution is able to conduct investigations and prosecutions without undue influence from government or any other inappropriate sources, and will be able to perform its professional duties freely, fairly, impartially, and objectively, and with respect of human rights. A number of international instruments have been adopted to that effect. Nevertheless, it has been suggested by scholars and others that the MPS is not really independent of neither the minister nor the military. With a view to the independence of the government, the Danish system differs from a number of justice systems in that both prosecuting services are under the supervision of the minister of each of the two parallel jurisdictions. After a debate in Parliament some years ago, legislative amendments were adapted with a view to support transparency as a safeguard against undue influence. So if the minister would wish to issue orders in a specific case, the order must be issued in writing, and the President of Parliament must be informed. So this has never happened. On the contrary, our minister has applied an arm's length principle and has published this view in an answer to Parliament. The second part is independence from the military. The WikiLeaks leakage of confidential documents spurred a debate by media and Parliament pertaining to MPS independence from the military, in particular in connection to our investigations in civilian casualties in Afghanistan. It's of course true that particularly the military police have been a valuable asset for us in international settings and have acted as a first responder in a number of serious incidents. So although the concerns would be a matter of perception rather than reality, we have adopted some mitigation policies. The first is some guidelines. They have been issued with a view to instruct the military police officer that they are under the command and control of the prosecutor and independent of the chain of command. Further, we have some secondment schemes to enhance military police skills and understandings. Recruitment will also be an element. I'll come back to this. And then transparency and appearance. The constant news coverage from the media players and social media places a great demand on adequate communication. We have historically been subject to significant public attention, so we have therefore seen it fit to focus on how we, on a daily basis, clearly conveys our role as independent military prosecution supporting discipline and a fair process. This approach has inter alia been supported by the Chief of Defense in a, I have to say, most welcome statement when feelings ran high some years ago, and I quote, "It's only natural that it's an independent authority outside the military that investigates and prosecutes military criminal cases. The independence of the military prosecution service must never be doubted. This is how it should be in a democratic society with independent courts," unquote. So the next item I'll touch upon would be issues like skills and efficiency. For any organization, the quality of its products is obviously essential for survival. The staff simply have to have the right skills and be efficient. The one jurisdiction supporters argue that a limited caseload may have an impact on quality. It might be a challenge to maintain an environment of competences and professional milieu with exchange of experience if the caseload is very low, and because legal knowledge has to be supported by practical training and into dealing with criminal cases. The second part is recruitment issues. Military prosecutors and investigators must professionally be on level with their civilian counterparts. Diversity is in focus in recruitment process, and recruiting personnel with adequate skills is therefore paramount. We tend to recruit excellent trial lawyers from the CPS, and experienced police investigators, but also legal advisors and other staff with a military background, in particular with operational experience. We have even recently recruited female investigators with a variety of expertise, including in dealing with sexual harassment and offenses. Training is another aspect that's of value here. Appropriate training is extremely important. So we send our new prosecutors through extensive CPS prosecutors training courses, and investigators go through the national police training programs and secondments. The final parts would be the military understanding and expertise, which is, in our view, a precondition for a legitimate military justice system. Any legitimate system has to enjoy public trust and confidence, as well as the support and trust of the users of the system. A military prosecutor has on one hand to be an experienced lawyer, used to prosecuting criminal matters, and on the other hand, to appreciate the preconditions of military service and have adequate military knowledge. I'll just give you an example of the delicate balance between these two poles, the two tight connections item. From time to time, it has been argued that the MPS has too tight connections with the military. So, a few years ago, we recruited a lieutenant colonel with a law degree who had just returned from Afghanistan as a military advisor and junior prosecutor. We did not avoid criticism for this decision, which was taken after careful considerations. So this is how it is. The final point here I touch upon is the prosecutorial decisions and acquittals pertaining to the quality of the military justice system. Occasionally there's been dissatisfaction with procedural decisions, in particular whether a matter should be an indictment or a decision not to prosecute. And it's important to stress that the decision to pass charges is a result of careful considerations of the merits and evidence of the case, inter alia the information that was available for the accused at the time and place of the act. We take our responsibilities very seriously and only brings, of course I would add, such cases to trial where there are reasonable grounds to do so. Whether an indictment is popular or not is not a question, and of course controversial cases are brought to trial, notwithstanding they might cause some turmoil. We have seen as well in the news too many acquittals, but this has had no impact. We believe we have a sound conviction rate. Recently, I might add, a Major General was convicted of corruption, and other recent convictions comprise rape in Afghanistan and serious economic and arms cases with long prison sentences. I don't know how long time I have left, Mr. President. Yes? Okay. I would like to just mention that we have, and we and all military justice system would have a number of challenges pertaining to international cases, inter alia, due to the jurisdiction issues. All troop contributing countries, they bring their jurisdiction to the country, the host country, and of course this would create some issues which I might elaborate on later on. The host nation jurisdiction would also be a challenge, as we have no jurisdiction over the nationals. I just touched upon two, I believe we have time for that, two judgments from the European Court of Human Rights. The first one is Chalou versus the Netherlands. It's a shooting accident in a checkpoint. The Grand Chamber found that the Dutch authorities had breached the procedural duties under Article 2 of the Convention and criticized inter alia that the Dutch had used an Iraqi physician to perform an autopsy that was not state-of-the-art. It's of course comforting that 6 judges in their joint concurring opinion regret that the Grand Chamber and eyesight also found it appropriate to scrutinize an investigation in Iraq in such a painstaking way that eyebrows may be raised about the role and competence of our court. We used to call this case a bridge too far case. I don't have time to go into details with the Hanan versus Germany, But here the Grand Chamber accepted a broad margin of appreciation, maybe as the death occurred in active hostilities. So with a view to incoming challenges, of course, we have the issue of further civilization or extracting specific crimes from the military justice system, as I just mentioned. And finally, I just touch upon the change of pattern of operation we have seen since the terrorist activities emerged in many European countries. We have seen soldiers in the streets, and new legislation has been adopted in several countries, including Denmark and Norway, with a view to dealing with post-incident investigations during military assistance to the police. This legislation has transferred a chunk of the military justice system into the civilian system, so investigations are now conducted by the Independent Police Complaints Committee, the IPCC, as it has been seen fit that military assisting the police would be subject to the same rules. But we have still a small role assisting the IPCC. So let me sum up. We believe that there's an obvious need to preserve a sound, transparent, and legitimate military justice system for the benefit of the armed forces and its personnel. It's essential to preserve public trust in the system, maintaining professionalism and integrity, and staying tuned to the development in society. But at the end of the day, it's a political matter, and the result may even depend on the political climate at a given point in time. Thank you very much for your kind attention. Merci.
Merci, Monsieur le procureur général. Merci pour la présentation de ces aspects organisationnels et procéduraux. En fonctionnement, en organisation, ça me fait penser notamment à ce qu'était le tribunal aux armées de Paris entre 1999 et 2011, avant que ces compétences ne soient transférées aux juridictions civiles. Vous nous avez présenté aussi les principes fondamentaux de la Cour européenne des droits de l'homme, en particulier l'indépendance des poursuites, les principes qui s'appliquent également aux phases de jugement. C'est précisément le sujet que nous vous avons confié, et nous vous entendons, Monsieur le juge avocat général du Royaume-Uni, maintenant sur cette question.
Good morning. Thank you very much for your invitation to this prestigious conference. Thank you for hosting it here. I thought I had an impressive court in London. I now realize it's nothing. This is incredible, and it's a great honor to be here. Can I also just take a moment to thank the interpreters who have made my life worth living for the last day and will help me enormously for the rest of today. Thank you very much. Before I start my presentation, Mr. Guillon has asked me to explain what is a Judge Advocate General. I'm not a general, I'm not an advocate, but I am a judge. It's a historic title. It dates back to 1666. I think I'm the 54th Judge Advocate General. The general part is the same as we have an attorney general or a solicitor general. We have a judge advocate general. It's not a military rank. The advocate part is a historic role. Back in the centuries before, the judge would have an advocacy role in taking an advocacy role in the proceedings, but none of that happens now. So I'm going to talk to you a little about the influence of the European Court of Human Rights on the current military justice system back home in the United Kingdom. And I need you to use your imagination. I want to take you back to the late 1980s. I want you to imagine me as a young, handsome, okay, that's a bit too far, a young lieutenant commander in the Royal Navy. I'd recently qualified as a barrister, at the Bar of England and Wales. I was, as we say in England, keen as mustard. Perhaps you have a similar expression. You have very good mustard in France, so maybe you do. I was in my first legal job in the Royal Navy. I was the staff legal advisor to Flag Officer Plymouth. Flag Officer Plymouth was the admiral in charge of all things naval in the local land and sea area in the southwest of England, and I was his lawyer. He was what we call the convening authority for trials in the court-martial. Under his authority, I did all the work. I appointed the prosecutor, that was usually me. I appointed the judge advocate, as we call it in our jurisdiction. And the judge, he or she, would be a more senior naval officer and a more experienced lawyer, and they would sit as the judge on the trial. I sent out the signals. We didn't have email in those days. I sent out the signals to the ships and the local shore establishments to obtain the president of the trial and the board members. You'll hear me use that expression, board members. That's the jury. We call it a board. It's the jury. I decided what charges the defendant would face, and I took them up to the Admiral for him to approve. I then prosecuted the trial, and I would report back to the Admiral on how it was going. The president of the board, the jury, was a naval captain, 4 rings, senior naval officer. He was the president. He was just that. He ran the trial. But as a naval captain, he had no legal training or experience. The judge advocate, was simply an advisor to the president, to the captain, and to the board on law and sentence. The judge took no firm role in the sentencing decision. And after the trial, in the Army and the Air Force, not in the Navy, but after the trial in the Army and the Air Force, the convening authority, a general or an air marshal, confirmed the verdict and the sentence, tick, but also had the power to quash, to annul the sentence and the conviction. So that was the system, and I was involved in it. And at the time, to be honest, it just seemed to work fine. When I sent out the signals to try to get the board members, the jurors, I didn't try to get a particular type of naval officer who was going to convict. It was difficult enough just to get a body into a chair. And looking back, I genuinely feel that justice was done in our system. But looking back over the other shoulder, it's difficult to understand how that system, riddled with the opportunity for executive interference, could have survived for so long. At that time, late 1980s, not much had changed in the court-martial since the reforms which followed the Second World War. Each service, the Navy, the Army, the Air Force, had its own justice system, and they had developed to suit the needs of each service. There were, as we've already seen, variations in practice between each service. And this will become important a little later. The Navy had naval officers, as I've told you, as judge advocates. They also had naval officers prosecuting and naval officers defending, all lawyers, but it was very in-house, as we say. The Army and the Air Force were different, as they always are. They had civilian judges and they had civilian lawyers defending. So let's move on a few years. In 1991, Judge James Rant was appointed the 52nd Judge Advocate General. He was a very senior and respected Old Bailey judge. The Old Bailey, as you probably know, is the Central Criminal Court in London. And when he came into office, he warned the Ministry of Defence and the armed forces that their justice systems were not compliant with the European Convention on Human Rights. And he proposed that the system should be changed in a planned and considered way before change was forced upon them by the European Court. Sadly, the armed forces did not heed his warning. And a storm had started brewing a year before. In 1990, Lance Sergeant Alexander Finlay was serving in Northern Ireland with the British Army. It was a difficult time, as you may recall. He was 30 years old. He'd fought and been injured in the Falklands War some 8 years before. That day, the day I'm talking about, he'd had a good day out. He'd been on a pigeon shoot with the Royal Ulster Constabulary. That's the local police force. Unfortunately, later, back in barracks, after a lot to drink, things went badly wrong. He took out his pistol, he cocked it, he pointed it at Guardsman James McWilliams, he pressed it to the head of Lance Sergeant Derek Reynolds. He went to another room, he actually shot the television. We've all wanted to do that sometimes, but he actually did it. He then aimed the pistol at 2 other soldiers. There was evidence in the case that he'd suffered from post-traumatic stress disorder as a result of his service in the Falklands. Importantly, he pleaded guilty at a court-martial to a number of charges of assault, conduct prejudicial to good order and military discipline, and threats to kill. Sentence: he was dismissed from the army. That's a sentence we can impose. He was sent to prison for 2 years. He appealed the conviction, even though he pleaded guilty. He challenged the fairness of the system, and he took it before the European Court of Human Rights. And it took 5 years, as you may understand, before his case was finally concluded. Finlay argued that his trial was neither independent nor impartial, and that he was denied a fair trial. And the court found that the procedures we used in that trial did not comply with Article 6, and he did not have his right to a fair hearing by an independent and impartial tribunal. Now, I don't know if it's the same in France, but when you become a judge in Britain, your ability to control any form of IT is taken from you. So just bear with me while I try and make this work. This one? There we are. So there are 2 parts to the judgment I want to read to you. As to the question of impartiality, there are 2 aspects to this requirement. Firstly, the tribunal must be subjectively free of personal prejudice or bias. Secondly, it must also be impartial from an objective viewpoint. That is, it must offer sufficient guarantees to exclude any legitimate doubt in this respect. It's noteworthy that, and this is them commenting on the court-martial, all members of the court-martial, appointed by the convening officer, the general, were subordinate in rank to him. Many of them, including the president, were directly or ultimately under his command. And they went on. In order to maintain confidence in the independence and impartiality of the court, appearances may be of importance. That's really important, I think. Appearances may be important. Mr. Finlay's doubts about the tribunal's independence and impartiality could be objectively justified, said the court. In addition, the court finds it significant that the convening officer, the general, also acted as confirming officer. Thus, the decision of the court-martial was not effective until ratified by him, and he had the power to vary the sentence imposed as he saw fit. This is contrary to the well-established principle that the power to give a binding decision, which may not be altered by a non-judicial authority, is inherent in the very notion of tribunal, and can also be seen as a component of the independence required by Article 6. Would you like to come in? Please. Finlay was the start of a series of cases in which the European Court of Human Rights considered the fairness of UK's military courts. By the time Finlay was finally decided during those 5 years, the Ministry of Defence had woken up and realised that Judge Rant had been correct in his predictions, and they'd started to make changes. The Armed Forces Act of 1996, bear with me, abolished the all-encompassing role of the convening office or convening authority. That went. So the local admiral that I worked for, who had all that power, that was abolished. Instead, the role was divided into a court administration officer, civilian, with some guarantees of independence, and it was their job to find the president and the board members, the jury. Independent prosecuting authorities were set up for each service, taken away from the chain of command, although still at that time headed up by a serving officer. And the judicial role was enhanced to improve and reflect the role of civilian judges. But the power of the executive to review convictions and sentences in the court-martial was not abolished at that stage, and it was extended to the Navy as well. But what was changed was that the review process was limited to interfering in the conviction or sentence only if it benefited the defendant. So it could quash a conviction or reduce a sentence, but not do anything adverse. It was nonetheless still executive interference in the findings of a court of law. And as I've said, the judges' roles were enhanced. Judges became at the centre of the court. They controlled the proceedings. They decided issues of law. They directed the board on legal issues. And they were at the heart of the sentencing process rather than simply advising on it. Naval judges were not abolished until 2004 under the case of Greaves against the United Kingdom. And this is one of my favourite ECHR judgments. So what the court said was this: the court finds unconvincing the government's explanations as to why a serving officer, a naval officer, was to be preferred as a judge advocate in naval courts martial. That's to a civilian, preferred to a civilian. So they gave the government argument. The government relied upon the knowledge a naval officer would have of the unique language, customs, and environment of the Royal Navy. Now, I was a Royal Naval officer. There is a unique language, and there are some customs, but perhaps not so much. And they went on. However, it is difficult to understand why a detailed knowledge of the way of life and language of the Navy should be called for, particularly where, as in the present case, the offence with which the applicant was charged was the ordinary criminal offence of malicious wounding. So it was just a punch-up. And they go on. The government further relied on the need for the naval court-martial system to be flexible and portable. This was the government's argument because of the particularly mobile nature of the Navy. Naval judge advocates were therefore preferable as, inter alia, they would be better prepared for the difficulties and dangers of working at sea. However, said the court does not find this relevant, given the government's clarification, which the court had asked for, that naval courts-martial have in fact been held on land since 1986. So it was a duff point, as we say. Sorry for the interpreters, that's a tricky one. Interestingly, my ambition as Judge Advocate General is to have trials in the court-martial back at sea. And we have a global deployment, as you might know at the moment, NATO deployment, with the new aircraft carrier, HMS Queen Elizabeth, making its way around the world with sailors and Royal Marines committing offences as they go around the world. And I'm trying to avoid a big backlog at the end. And I wanted to take a court somewhere halfway, probably somewhere sunny, and have a series of trials to demonstrate we could do justice But it was the first of these deployments with the new ship, and there's a global pandemic, so the timing was wrong. But watch this space. It's an ambition I have. Anyway, back to the brief. Further changes followed. It led to the Armed Forces Act 2006, a major reforming piece of legislation. It consolidated the prosecution authorities into a single independent prosecuting authority under the direction now of a senior civilian lawyer. So that's headed by a civilian. Review, any form of review of a decision of the court was abolished. And so now, as it should always have been, a court's decision is final, subject to the usual appeal processes. So the power of the executive to interfere was removed. So, we no longer have an admiral or a general in charge of justice. There's a civilian administration. The judges are all civilian. The prosecuting authority is run by a civilian. How did that go down with the armed forces? As you might expect, unification into a single system of justice and the civilianization of that system was not always welcomed by the armed forces. And there was, to be frank, considerable resistance along the way. And Lars and I were talking last night about the first director of public prosecutions who felt hostility to him from some areas of the armed forces. Some observations by senior officers at the time were these, and these were people giving evidence to the House of Commons as the Armed Forces Act was being considered by the Parliamentary Committee. General Sir Mike Jackson, hugely respected officer as Chief of General Staff, he said this: each service has its own ethos, and that's right, and proper too. We do different things, and we do them in different ways for very good reasons. Ethos is part of the military jurisdiction system, and I think we need to bear that in mind. The Royal Air Force, Air Marshal Sir Jock Stirrup, he said this: what is crucial in terms of maintaining that bond of trust is that people understand and feel that their actions are going to be judged in the context in which they are operating, not as if they were walking down, dare I say, Watford High Street, but the fact that they were in downtown Basra, with everything that implies. I don't know if you've been to Watford, but you can probably imagine what he means. General Sir Michael Walker, he said this: what you need is people making judgments who do understand the context of those who are being accused of some crime. So 24/7 living, stress, pressures, finding yourself in a riot in some godforsaken part of the world produce pressures on people. And when you're looking at making judgments about what they do, it requires you to have an understanding of that context. Has it worked? Have those genuinely held concerns by those highly respected senior military officers been addressed? I think so. Guilt or innocence is still decided by a board, a jury, of serving officers and warrant officers. And they understand the all-important issue of context. I've seen that for myself when dealing with cases involving soldiers who've recently returned from operations in Afghanistan, where they were exposed to considerable stress. Many of the board members have themselves served on operations, and they understand the pressures that such service brings very well. So when we sentence, and the judge in the court-martial sentences with those officers, each has an equal vote, they bring the relevant issues to bear, working with me, the judge, to reach the right sentence. And interestingly, many of my civilian colleagues who work in the civilian courts, when they get a soldier charged with an offence who's served on operations and has some issues resulting from that, they feel less able to put it into context because they don't have that guidance that I do from my colleagues on the board. So it's slightly ironic that the civilian courts have even less context. Am I confident that we have a system which is compliant with Article 6? I think so. Not least because it hasn't faced challenge since 2003, when the summary system, so below the court-martial we have a summary justice system with the chain of command operating it. The European Court looked at that and they were content with most aspects of that. But just to finish, the legacy of the old British legal system continues to cause problems elsewhere in relation to military justice, particularly in the Commonwealth. Historically, many nations in the Commonwealth adopted similar legal procedures to those in force at that time in the UK, before the ECHR's involvement. Our friends in Canada continue to struggle with the issue of military judges. Their judges are serving officers, they're not uniformed in court. And I must say this, from the judgments I read from judges in Canada, they are extremely capable judges. But I ask rhetorically, are they sufficiently independent? Or perhaps putting it a different way, do they appear to be sufficiently independent? Remember that from the judgments. A recent major review of the Canadian military justice system by Justice Maurice Fish thought not. Other smaller Commonwealth countries have systems of military justice which have remained virtually unchanged for decades and which they acknowledge are not really fit for purpose. And I'm working at the moment with the Commonwealth Secretariat to develop a programme to try to assist some of those countries, particularly the smaller countries. Canada is perfectly capable of doing it on their own. But smaller countries without the infrastructure and resources who want to modernise their military justice legislation and trying to provide them with the learning and resources to do that. It's early days in that project, but perhaps, Monsieur Guillon, I can come back in a few years and tell you how we're doing. Thank you very much.
Merci pour cette présentation d'abord en forme d'état des lieux, puis pour nous avoir montré de quelle façon le système était compatible avec les principes de la Cour européenne des droits de l'homme. Et on voit bien qu'il y a un impératif partagé, c'est que soient prises en compte les exigences propres au métier des armes et notamment les éléments liés au contexte d'emploi des forces. Vous aurez certainement des questions à la fin de la matinée. Nous avons été rejoints par le professeur Mario Ferreira-Monte, qui est professeur de droit pénal et de procédure pénale à l'université de Minho au Portugal, qui est également membre et fondateur de l'Institut ibéro-américain de droit militaire et coordinateur du réseau lusophone de recherche en droit. Et vous allez nous faire une présentation en forme de droit comparé entre le Portugal, le Brésil et l'Angola. Je vous cède la parole, monsieur le professeur.
Merci beaucoup, monsieur. Bonjour. Juste quelques mots en français, mais ensuite, je vais parler en anglais, ce qui est un peu plus facile pour moi. Et je vais parler aussi lentement pour aider les traducteurs. Monsieur le Président, Mesdames et Messieurs les autorités, chers professeurs, Mesdames et Messieurs, je souhaite tout d'abord remercier le ministère de la Défense, l'Académie militaire de Saint-Cyr, le musée de l'armée et la Cour de cassation pour leur invitation. En particulier, merci à mon ami, à notre ami, je peux dire comme ça parce que c'est notre ami, M. Gwenal, pour cette magnifique organisation. Ce que je vais présenter est une courte communication qui ne doit pas dépasser 20 minutes, mais je vais bientôt envoyer un texte plus long, avec plus de détails, pour une éventuelle publication. So, at times for these times, with this sentence, which gave the title of one of Charles Dickens' books, we can better understand the situation that is currently being experienced in Portugal in military justice system. All because of the diamond trafficking and money laundering carried out by Portuguese soldiers serving in the United Nations mission in the Central African Republic by these days. The questions these days are obvious. For what crime, criminal norms, will the military be tried? And what jurisdiction will judge them? These questions also legitimate pose the other problems. Is military criminal jurisdiction legitimate? Is a military justice system that is autonomous from the common system justified? These difficult questions do not have the same answer in Portugal, which is a small country, Angola. I am a member of the Reform Committee of the Military Justice in Angola, or Brazil. 3 Portuguese-speaking countries which serve as examples to understand the variety of military justice solutions in the 9 countries of the Portuguese-speaking community. To answer such questions, everything depends on 2 central points. How is military crime defined? Should there be a military jurisdiction to judge military crimes? Portugal, in the Code of Military Justice, adopted the notion of strictly military crime. It rejected a broader notion of military crime, or essentially military crime. This choice is relevant and has major implications. The material criterion that underlies the notion of a strictly military crime is double. That of the legal asset, the value protected by the criminal norm, that is military interests, and that of the functionality of these assets to serve military interests of national defense, and of the other that the Constitution entrusts to the armed forces. The military institution and this function legitimized this special incrimination. Therefore, the connection between the Penal Code and the Code of Military Justice in Portugal shows that for it to be a strictly military crime, it is not enough that the typical unlawful and guilty act affects military interests. It is necessary that it involves qualified military interests. That is to say, such interests must have military relevance and exclusively only military relevance. Returning to the case of the Portuguese soldiers on a United Nations mission in the Central African Republic, they did not actually commit military crimes in the sense of strictly military crimes. They committed common crimes, the crime of diamond smuggling and the crime of money laundering. And so in Portugal, this military personnel will be tried in ordinary civilian courts. If they were strictly military crimes, they would be tried in mixed jurisdiction, civilian and military. This poses significant procedural implications. The legal position of the subject is defined according to the crime of which he or she is accused, If the crime is one of those, for instance, in the military justice code, because it is strictly military, the procedural norms of the Code of Criminal Procedure apply. If the crime is a common civilian crime, regardless of who committed it, the rules of the Code of Criminal Procedure are applied exclusively, with all the implications that this entails. Could it not be like this? Of course, it could. Portugal once had a different notion of military crime, essentially military crime. The difference lies in the fact that essentially military crime still made it possible to cover crimes whose assets or interests armed were essentially but not entirely military, whereas the notion of strictly military crimes implies that the assets or interests protected by the type of or are only exclusively, integrally, strictly military. Curiously, the distinction between essential and strictly military crimes is of much greater interest in Angola or Brazil than in Portugal. Because in Portuguese law, this distinction only serves to limit the criminal sanctions given that military courts do not exist. Simple. There are only mixed courts. There are civilians with the participation of military judges. But in Angola and Brazil, the nature of the crime, besides limiting the special criminal sanctions, also serves to define the competence of the military courts. Having said that, what is the importance of considering the notion of an essential military or strictly military crime for the purpose to defining the competent jurisdiction? One could say that it is a matter of giving greater or lesser weight to military interests. Strictly speaking, everything has to do with the relevance of giving the military jurisdiction higher or lower powers of cognition. While it is true that the existence of essentially military crimes in much bigger numbers than strictly military crimes justifies military jurisdiction, it is also true that choosing strictly military crimes may dismiss military jurisdiction. In Portugal, for example, there are no military courts. Strictly military crimes are tried in ordinary crimes, as I said. The questions that may be asked, however, are different. Is the adoption of the notion of an essentially military crime justified because there is an autonomous military jurisdiction? Or is the autonomous military jurisdiction justified because there is a notion of essentially military crime? Or there are other reasons that justify both? Of course, adopting notion of an essentially military crime significantly expands the number of military crimes and consequently may justify the existence of an autonomous military jurisdiction. Not only to relieve civil common jurisdiction of military crimes, of course this is important, but also for reasons of material speciality. But if the notion of a strictly military crime is adopted, Or this mean that autonomous military jurisdiction is unnecessary? The answer, which in Portugal is affirmative, refers us to the process of revision of the military justice code that is underway in Angola. Currently, in Angola, only essential military crimes are judged in military courts. But with the ongoing revision of the military justice code, the discussion remains. In the future, should military courts judge essential military crimes or only strictly military crimes? And this is a very important question in Angola. Of course, even in Portugal or Brazil or here in France. This discussion in Portugal would not make so much sense, but in Angola or Brazil, it makes perfect sense. The extent of the territory, the larger size of the military structure, have shown that an autonomous military judicial organization is essential. This means that autonomous military jurisdiction is justified, in our view, in countries like Angola or Brazil, even if a strictly military notion of crime is adopted. Since the number of strictly military types of crime is substantially smaller than that of essentially military crimes, even so, given the size of the armed forces and the police in countries like Brazil and Angola, the number of cases would always justify an autonomous military jurisdiction. Can we then conclude that autonomous military jurisdiction is only justified by the size of the armed forces and the police? If it is true that this dimension can have a significant impact on the answer, the truth is that this is not the only reason why the option should be made. It is a decision that is also political. A political decision that is related to the foundations of the democratic rule of law. The question, which is not innocent, is the following. Does an autonomous military jurisdiction, even if only to judge strictly military crimes, have the same legitimacy as a civilian jurisdiction to judge those crimes? This is the question. A negative answer would mean a certain distrust in the military judicial organization. For example, it could always be said that corporate interests, military corporate interests, could prevent it from carrying out impartial justice. This argument might justify the adoption of a notion of a strictly military crime. But in our view, it is not enough to justify a civilian jurisdiction, even mixed, composed of civilian and military judges. Naturally, when exclusively military interests are at stake, nobody wants impartial justice more than military themselves. Of course. All of this is under discussion today in Portugal. Not only of the case of diamond trafficking and the money laundering of the Portuguese military in the Central African Republic, but also because of two other recent cases. One, the case of the death of two recruit soldiers in the middle of armed special forces exercises, commandos, in 2016, and another case of the theft of weapons from the Tanco's Armory in 2017, in this case, resulted in the resignation of the Minister of Defense and his trial now in Portugal. Hard times for these times. What was thought to be consolidated, nevertheless, calls up this question. Are the instances of military justice believable? This is the question. The answer may help countries like Angola, which are reviewing military justice, to find a solution. In conclusion, our position is as follows. First, it would be wrong to assume that strictly military crimes interest the military and civilian crimes interest civilians. No. When legal assets are at risk, crimes, regardless of their nature, are of interest to everyone. Second, it would be wrong to assume that civilian courts do not have the capacity to try military crimes. In Portugal, with the presence of military personnel, civilian courts try strictly military crimes. 3, but it would also be wrong to assume that only civilian courts can achieve greater impartiality in the trial of military crimes. 4, therefore, the choice of military jurisdiction to try military crimes is, above all, a choice of judicial organization that has more to do with the efficiency of this organization than with greater or lesser guarantee of justice. More important for me than the establishment of an autonomous military jurisdiction, more important is the decision on the question of the existence or not of a military criminal code or a military justice code with strictly or essentially military crimes. This is the question. This is the question. This is the central issue. It seems to us that for several reasons, the speciality of a set of norms should only prevail when the legal assets are truly special, different. Therefore, it makes perfect sense to adopt the notion of strictly military crime. Essential military crimes always carry the risk of repetition of the offenses when this really is not even justified. In conclusion, the question that remains for reflection is this. When the legitimacy of a military criminal justice system is debated at the expense of media cases, as in Portugal now, such as the case of the diamond trafficking and money laundering, that these days has affected the Portuguese armed forces. Is it the military system we are talking about, really? We are not even talking about military crimes. We are talking about ordinary, purely civilian crimes committed by military personnel. This has nothing to do with military criminal justice, except for the possibility of disciplinary sanctions being applied. It is not military crime justice that should be evaluated in these kind of cases. However, there is no shortage of people who simply wanted to abolish the military criminal justice system because of this kind of cases. It is the form of things that shapes the reality of things. Hard times for these times. Thank you very much.
Merci pour la présentation de ces différents modèles juridiction militaire autonome, modèle mixte, les problématiques afférentes, et notamment en fonction des particularités territoriales. Merci à nos trois intervenants. Nous allons faire une pause d'une quinzaine de minutes avant de faire un focus sur l'Australie, puis répondre le cas échéant à vos questions et pour l'ensemble de nos intervenants.
No, I think it's broken.
Yeah.
No problem.
Okay.
No worries.
Sorry,
I thought so as well.
Just a small
Yep, I've got the USB.
So maybe just what time do we?
It's for
Is there a
4:20.
is there a break just before? Or?
Yes.
Yes. So maybe during the break we can place it in the computer.
Okay.
Okay.
Bonjour. De Luxembourg, je suis Elisabeth de Brésil. So, you come from Cornell University.
Yes, I live in Canada, and I drive downtown. It's about a 4-hour drive. Yeah, but I came here from Canada, Ottawa.
4 hours.
Yeah, it's I do it once a week. I do the drive once a week. So it's if it were more than that, I would be a little more reluctant to have that arrangement.
So every day?
Just Tuesdays. Just Tuesdays, yep. Right now I'm teaching law and ethics of armed conflict. Law and ethics of armed conflict. Last spring it was comparative military justice. And this coming spring will be looking at contemporary challenges in U.S. foreign policy in relation to international law. So the connection.
There is a colleague of mine that I think every year come to Cornell as a visitor professor from the University of Milan, Rossella Cerchia.
Yeah. Just comes for a visit for just a bit, or?
As an invited professor,
Yeah, yes.
so I think 6 months. Yes, more than once. All the things.
Yeah.
Of the law, very
Yeah. It's I just kind of happened into the university. A person who became a friend of mine was a professor at the time at Cornell Law School. He's now the dean. But before he became the dean, he became vice dean, and he had to offload some of the courses that he taught, including the course that I teach now. And so, because I was just finishing up with my master's in law, and the timing worked out well, he just said, "Hey, if I know you're qualified. I'm retired from the military." He said, "I know you're qualified to teach this. Do you want to fill in for me to take this over, at least while I'm vice dean, and we'll figure it out from there." And then he served as vice dean and elevated to dean. And, so I think I'll keep the classes that I teach for now. And then I don't know that when he relinquishes the dean position, I don't know that he'll want to come back and teach this stuff or move on to different things. So, yeah. Do you come here from Italy?
Yes, from the University of Milan.
Oh, yeah. Okay. And how long have you been with the university? How long have you been with the University of Milan? Wow. Yeah. Yeah, that's great. Are you coming here to present?
Yes, yesterday,
Yeah. Okay.
because I'm a legal historian.
Ah, yes.
So the first day about history, I studied transitional justice. So I focus on military support, transitional justice power, Second World War.
Yes. Yeah.
With the mask, I couldn't understand
Oh, yeah.
exactly because my English is
hard.
not perfect.
Sure, yeah.
It's difficult.
Yeah, I missed the whole day yesterday because I had problems with my flight connection. Yes, right. Yeah. The original plan, if the flights had gone as according to plan, is I would have arrived here yesterday just as the conference was beginning. So I'd have missed the first presentation or two, but still be fine. But I had my flight leaving Ottawa, my first departure, was late leaving, so I missed my connection. And so I ended up.
When are you coming back?
I go back tomorrow afternoon. Yeah, just very quick. Yeah, unfortunately.
A long trip.
It is, yeah. My father-in-law is his birthday celebration is tomorrow, so I need to make it back for that.
It's impossible to miss.
That's right.
Excuse me, are you Raffaella?
Yes.
Ah, okay.
Hi, nice to meet you.
Ok, my name is Michelle. No, parliamo italiano. Ok.
Fantastico.
Allora, io sono francese, sono adesso retired judge. E volevo rimanere ieri pomeriggio, ma non ho potuto, ma posso avere il suo non so, discorso più tardi? L'avrò? Ok. Ma lei ha parlato italiano ieri?
No, in inglese.
In inglese, ok.
Sì, perché tra
ok.
francese e inglese mi sento più a mio agio in inglese e
Ok.
al momento non ho il testo.
Ok. No, ma non era in italiano. No, io la mia come si dice in italiano? Come si dice business card?
Biglietto da visita.
Biglietto della visita lo do, ma soltanto per scambiare in italiano, perché ho detto ma come mai è un'italiana che viene a Parigi che non posso rimanere? Ieri non ho potuto rimanere. Dunque, e lei... Ma io l'ho studiato l'italiano a Parigi. Ho fatto studi di traduttore quando ho finito, quando ero stufa un po'.
It doesn't work.
Il marche pas, on dirait.
I think
Sì. Adesso la vengo a trovare.
Bien, nous allons reprendre nos travaux si vous le voulez bien. En faisant un focus sur l'Australie, nous aurons deux interventions. D'abord, l'intervention du capitaine John Devereux, qui est officier juriste des Forces armées australiennes, et ensuite une intervention à double voix d'Alison Duxbury, qui est professeur de droit à l'Université de Melbourne et Associate Director of the Asia Pacific Center for Military Law, ainsi qu'accompagné de Rain Livoja, qui est professeur associé de droit à l'Université, cette fois-ci, de Queensland. Voilà, nous allons laisser la parole et entendre le gros capitaine John Devereux, qui va faire tout d'abord nous parler des fondements constitutionnel et législatif du système de justice militaire en Australie, analyser différentes décisions et ensuite dresser quelques perspectives et en nous parlant de quelques réformes probables. Voilà, je vous laisse la parole.
I have a question. Can I? Okay.
Furtivement à l'écran.
Oui, madame. Oui. Thank you, ma'am. I'll just share my screen if that's convenient.
It's okay.
I'm trying to share the screen. It won't come up. Where is it?
Did I open on it?
Yes, yes, it is. Sorry. Wait. Where the fuck is it? Thank you, baby. I really appreciate it. Sweetie, can I need your help? Wait, sweetie, I just need you. Can you share the screen?
Sharing at the moment.
Sharing? Yes? Okay. Thank you. Mesdames et Messieurs, Monsieur le Président, ladies and gentlemen, thank you very much. Can I just confirm you can hear me okay? Thank you so much. I apologize for the technical difficulties from here. Look, it's wonderful to be at this conference. Thank you so much for inviting us, and we're very honored. Can I echo the thoughts of His Honor that it's a magnificent venue. I only wish I was there. It's a rather warm night here in Brisbane. What I'm going to take you through is a couple of things today. And I know you're probably not looking forward to some of this, so hopefully we'll make it a little easier for you. I know some of you are thinking it's going to be another lawyer arguing about jurisdiction. Here's a picture of my dog, and that was a live picture taken when I was preparing this presentation. And but the good news is he's been supervising. You'll see that's me sitting next to him with a COVID-like beard on. The beard is now gone because I'm a serving officer. So what am I going to talk about with Winston's help? I'm going to talk about a little bit about the structure of the discipline law system. I'll talk about some controversies that have arisen, and some of them will echo the comments of His Honour, the Judge Advocate General of the United Kingdom. And then briefly, I want to focus on a very recent decision here, the case of Private R and Cowan, which has turned our system into some stage of, excitement. And finally, I want to offer some comments on the future of the military justice system. So the first question I want to raise is if anyone knows who this man is. And I've listed 4 choices. The first is, of course, the eponymous hero from Top Gun, Maverick Mitchell. The second is William Bligh, who the Judge Advocate General will be able to tell us was tossed unceremoniously off a ship by Fletcher Christian. The third is James Tiberius Kirk, who of course was on the USS Enterprise. And the last is actually the true answer. His name is David Collins. He was the first judge in Australia, and he was a judge advocate of the colony of New South Wales. And so the first judge in Australia, or the first justice system in Australia, was military justice. So there's a very strong attachment here to the traditions that we've inherited from the British. It's worthwhile talking about some key concepts that operate under our system. The Constitution of the Commonwealth of Australia vests the judicial power of the Commonwealth in a group of officers under Chapter 3 of our Constitution. And that Constitution says that in order to exercise the judicial power of the Commonwealth, it can only be done by someone appointed by the Governor-General, who is the Queen's representative in Australia, until a person has to have tenure until they turn 70. They cannot be removed except by address of both houses of Parliament. Now, proceedings in Australian military courts are done pursuant to the Defence Force Discipline Act, and DFDA proceedings are not Chapter 3 courts, which is to say that our military judges, our judge advocates, our Defence Force magistrates, our commanding officers and our substers, and I'll talk about them in a bit, are not appointed by the Governor-General, do not have an appointment for life, and can be removed under the Act following certain processes. So if they're not judicial power of the Commonwealth, how are they valid? And the short answer is they're valid under our Constitution pursuant to what's called Section 51 Placidum 6 of the Constitution, the defence power, which is its own head of power. So seeing and noting that the problems that His Honour already alluded to in the Findlay jurisdiction, there was an attempt to modernise our system. And so the Australian Military Court was set up, and what it did was establish for the first time judges who were independent of the military chain of command, who could not be removed, but only for a 10-year period, and who made final and binding determinations. That is, they weren't reviewed by a convening authority or a higher authority. At the same time, an independent registrar of military justice was set up, an independent director of military prosecutions was set up, and an independent defence counsel services was set up. But unfortunately, a decision called Lane and Morrison, the High Court of Australia struck down the Australian Military Court. And they decided it was, to use the words of an English idiom, neither fish nor fowl. This was because they weren't judges appointed for life. They weren't appointed by the Governor-General. They therefore couldn't be Chapter 3 judges. But because the model departed so greatly from the British system of military justice, of court-martials, of confirmations, it wasn't a military court either. And therefore, it wasn't constitutionally valid under a normal federal judicial system, and it wasn't constitutionally valid as a military court. And so it failed. Other parts of the system have survived. We still have an independent director of military prosecutions. We still have an independent director of defence counsel services. And most importantly, we no longer have convening authorities. We have a registrar of military justice. There have been some other recent attempts to update the system. So what should you look out for when you're looking at our military justice system? Well, as I've said, it's governed by an act called the Defence Force Discipline Act. Now, prior to the act coming into force in 1985, like the British, we had three different systems of military justice. We had a naval system, an army system, and an air force system. And the DFDA, which was modelled closely on the Uniform Code of Military Justice, brought those three systems into a uniform approach to military justice. And you'll see from the slide that there are three levels. We retain summary hearings, what are called commanding officers trials, CO, a SUBSA, a subordinate summary authority, and that's basically a second in command or the XO of a unit. And we have what are called superior summary authorities who deal with senior officers at a summary level. Above that, we have superior tribunals. So we have retained the British model of restricted courts martial and general courts martial, but we've added to that a system called Defence Force Magistrates. So they are judges, military officers appointed to sit in judge-only trials, if you like, in the absence of a military jury that would be experienced in a court martial. Now, the most recent addition to the system you'll see at the bottom of the slide. It's called a discipline officer scheme. And a discipline officer scheme is limited in terms of the ranks to which it can apply. But the way it works is that an infringement notice can be issued to a member. If the member decides he or she wants to plead guilty, they can come before a designated discipline officer who will then mete out a punishment. All records of that punishment are extinguished after 12 months. So if you like, it's as if the matter never occurred. Contrast that with a conviction under restricted or general court-martial or Defence Force Magistrate trial. That is a criminal conviction for all purposes and therefore must be disclosed by an individual in the system or out of the system if he or she is asked if they have a criminal record. The discipline officer scheme is shortly to be expanded. The other things that are about to happen in our system is the subordinate summary authorities, that is the second in command of units, will no longer have any jurisdiction to deal with the Defence Force Discipline Act, and it will be swallowed up by an enlarged discipline officer scheme. There are also some recent developments to deal with some of the media offences or social media offences, people posting offensive matter online, to streamline the process of dealing with that type of offence. Let's turn to the most recent case then, the one that's causing a lot of excitement here. It's called the case of Private R. and Cowan. to understand the backdrop to that case, you need to understand that the High Court, which is our highest court of appeal, decided several times that the Defence Force could only exercise jurisdiction in circumstances where it had the purpose of enforcing or maintaining service discipline. What that led to was a number of pieces of litigation where, for example, assaults might have occurred in a private context, and the claim was they couldn't be dealt with by defence. So if you like to put it in an American context, it was the difference between the service status test, that is that the defence had jurisdiction if a person was a military member, whatever offence they committed, or a service connection test. And for a long time, the High Court said it was all about the service connection, not the service status. You needed to prove that prosecuting this person in the military system had the purpose of substantially enforcing or maintaining service discipline. So what happened in Private R in Cowan? The two people concerned, the complainant and the accused, were both defence members. There was a function that night. They'd previously had a relationship. The male, Private R, offered that the female could get changed in his room. He then propositioned her in that hotel room. She rejected his advances, and he then committed a serious assault on her. He was charged by the military using a section of our DFDA called Section 61, subsection 3. That section adopts into our criminal system all of the offences that could be charged in the civilian world in Canberra, basically the Australian Capital Territory. And we take that with us wherever we go. But under the prevailing view, you still had to prove that prosecuting was for the purpose of maintaining or enforcing service discipline. Well, somewhat unsurprisingly, the High Court said, yes, of course it did. That was a serious breach of discipline between two members of the same unit. But interestingly, the High Court changed the nature of the test, and they said that it was for the Commonwealth to determine what was maintaining and enforcing service discipline. And of course, having service members follow and obey civilian criminal law was an important part of maintaining service discipline. So overnight, if you like, we've enlarged the potential for criminal jurisdiction to be dealt with by the Defence Force, almost as if we'd moved from the service connection test all the way through to the service status test. And so we're waiting to see whether the Commonwealth embraces this with some excitement or not. I've placed on the screen there, you'll see my dog suggesting what we could look up. I've placed the electronic copy of the link to the judgment in Cowan's case, if anyone's interested in looking at it. And there are really two questions that arise then out of Cowan's case. One we've already discussed, whether there will now be an expanded role for the Defence Force Discipline Act in terms of prosecuting what until recently was done by the civilian courts, but bringing it in-house to the military courts. And the second interesting question is whether the DFDA proceeding, the military proceeding, is an exercise of the judicial power of the Commonwealth or an exercise of the executive power. And this is, I guess, really a matter for constitutional and administrative law scholars, but it is causing some excitement here. I'm just about out of time, but I'm happy to answer any questions now, or I note that there is a question session later this morning, so perhaps it's more convenient if we left it till then. Thank you again for inviting me. It's a real delight to be here, and apologies for the technical problems at the beginning. Thank you very much.
Sorry, I couldn't quite hear you. Could you please repeat?
Merci pour cette présentation qui était très illustrée et vivante. Je dis pas ça simplement pour le chien. Nous allons réserver, comme vous l'avez dit, les questions pour la fin de présentation. Et avec cinquième et dernière présentation de ce panel, avec une intervention à deux voix, toujours sur l'Australie, pour interroger deux modèles, military or civilian justice. Donc je laisse la parole à deux intervenants, Alison Duxbury et Rain Livojova.
Thank you very much. Can you hear me? Are you able to hear me?
Oui, c'est OK, c'est à vous.
Oui, oui. Merci. Greetings from Melbourne and Brisbane. Ryan and I would like to begin this presentation by acknowledging that we speak from the traditional lands of the Wurundjeri and the Turrbal peoples, and we pay our respects to their elders past, present and emerging. It is a great honour to contribute to this conference on international military justice, despite our disappointment in not being able to come to Paris in person. We both look forward to a time when travel will be easier and when we can meet those with our mutual interests in military justice in person. Today, Ryan and I would like to discuss the factors that may contribute to the decision whether to investigate and prosecute a member of the Defence Force through either the civilian or a military justice system. As a starting point, we recognise that military justice systems throughout the world have many different forms. In some countries, military justice is subsumed within the civilian justice system. In other countries, allegations of criminal conduct against service members are only dealt with by separate courts or tribunals. We are dealing with a third set of countries where there is a choice as to whether to investigate and prosecute through military or civilian authorities. The potential conflict may arise on both sides. A military justice system may claim jurisdiction over a matter which would otherwise be dealt with by the civilian system, or the civilian justice system may claim authority over a crime committed in the military context, for example, a war crime. This paper aims to examine the factors that are relevant when faced with this question: which avenue of justice could be pursued? These questions are sometimes tied to arguments about the legitimacy of military justice systems and whether they accord with states' human rights obligations, in particular the right to fair trial. And we've already heard discussion of that this morning. We won't be pursuing this line of inquiry in this paper. Now, the idea for this paper arose from the findings in the report called the Brereton Inquiry by the Inspector General of the Australian Defence Force, an inquiry that was instigated after allegations of war crimes by Australian Special Forces operating in Afghanistan emerged. The inquiry found that there was credible information to substantiate the unlawful killing of 39 people by the Australian Special Forces. Notably, the report recommended that any criminal investigation and prosecution of alleged war crimes should be undertaken by the federal civilian authorities. Decisions preferencing the civilian system have also been made in other contexts. And we've already heard, for example, of the fact that the Canadian Defence Minister has recently announced that allegations of sexual assault and sexual misconduct involving Canadian Armed Forces members will be moved to the civilian system, at least on an interim basis. Now, the question can also arise in relation to crimes that have only a small connection with military service. For example, a defence member who commits a crime, for example, murder, against a civilian while off duty, off base, and where there is no connection to the military. Further examples of such offences were raised in the recent High Court case mentioned by John. The plaintiff suggested that an Australian Defence Force member who drives a motor vehicle at an excessive speed while on holiday or chops down a protected tree in his backyard should be dealt with by the civilian system. Should such matters be prosecuted by the civilian system where there is little connection with the military, or should such offences be viewed as relevant to the good order, discipline and morale of the Defence Force? Now, before I hand over to Ryan and we look at the various factors which we've classified into formal and informal factors, I note two things. First, we will be drawing mainly on the experience in Australia, although similar factors are relevant in other systems. Second, although we have divided this paper into formal and informal factors, we recognise that there is some overlap, and indeed in some systems, what might be regarded as formal factors, because they are embodied in legislation, may be regarded as informal factors in others.
Good morning, everyone. Like Alison, I would have much preferred to be with you in person, to meet old friends and to make new acquaintances. but 2 weeks of hotel quarantine upon my return to Brisbane would have been a high price to pay, even for a trip to Paris. I will be discussing what we refer to as formal factors in the allocation of matters between civilian and military justice systems. But I should underscore, as Alison just did, that often these factors interact with each other, and the division into formal and informal ones is to some extent artificial. The first set of factors relates to the types of offenses and the applicability of criminal law. The overlap between military and civilian justice systems does not really occur where the offense is purely military in character. Consider, for example, absence without leave or insubordination. Since these offenses lack a civilian counterpart, the only option for their prosecution and trial is within the military justice system. This tends not to work the other way around. There are two reasons for that. First, many military criminal codes incorporate civilian offenses by reference. Consider the situation in Australia, which John has already discussed to some extent. A defence member commits an offence under the Australian Defence Force Discipline Act when engaging in conduct that would be a civilian offence if committed in the Jervis Bay territory. Just by way of explanation, Jervis Bay is a small part of the Australian mainland which is administered directly by the federal government and where the criminal law of the Australian Capital Territory applies. In other words, any criminal offence under Jervis Bay law is punishable under military law if committed by a defence member. A similar mechanism to incorporate civilian criminal law into military law is also used in many other common law countries, including the United Kingdom, Canada, and New Zealand. Second, there may be military offences that are so broadly defined that they effectively cover most, if not all, civilian offences. A prime example in this respect is the offence of prejudicial conduct under the US Uniform Code of Military Justice. The relevant provision captures all non-capital civilian offences and makes them punishable under the Uniform Code. The principal formal factor involved in resolving the potential competition between military and civilian justice is the question of the applicability and ambit of the law. In particular, the applicability of military and civilian criminal law tends to differ when it comes to offences committed abroad. Common law countries generally do not apply all of their civilian criminal law to offences committed by nationals abroad. However, they do make military criminal law applicable to all offences committed by service members abroad. Accordingly, prosecution under military criminal law and in a military court may sometimes be the only option. A good example of this is a case that ended up before the High Court of Australia, our constitutional court, in 2004. The matter concerned an Australian soldier who had allegedly raped a British tourist while both of them were on holiday in Thailand. The soldier was charged before a general court-martial. The High Court rejected a constitutional challenge by concluding that the matter was sufficiently connected to the discipline of the Australian Defence Force. But for present purposes, it is important to note that proceedings in the military justice system were the only option, as the alleged rape committed by an Australian national in Thailand is generally not punishable under Australian civilian criminal law. This factor is perhaps less significant in civil law countries that tend to apply their civilian criminal law to extraterritorial offences more broadly. But even then, there may be complications. Such extraterritorial application of civilian criminal law to nationals tends to be limited to the most serious offences. Alternatively, extraterritorial application of civilian criminal law may be subject to a double criminality rule. In other words, the conduct must be an offence both under the prosecuting state's law and the local law. In short, military criminal law may sometimes apply extraterritorially in circumstances where civilian criminal law does not. Now, constitutional principles potentially serve as another coordinating mechanism between civilian and military justice systems. Constitutional restrictions may come about in at least two ways. First, limitations may arise because of the way legislative power is conferred upon the parliament. For example, in Australia, which is a federal state, the federal parliament only has competence to legislate in certain constitutionally enumerated areas. One of such areas, as John has explained, is naval and military defense. So based on this legislative power, the federal parliament can only subject persons to military justice if that may be considered to conduce to promote to, or advance the defense of the Commonwealth of Australia. Second, constitutional principles may play a role by guaranteeing certain due process rights that are unavailable in the military justice system. For example, in the US, the Fifth Amendment to the Constitution creates a right to a jury trial, except in cases arising in the land or naval forces. Accordingly, military trials without a jury are only constitutional where they fall within this exception. Interestingly, the limitation that these constitutional rules actually place on military justice is showing signs of being read down or diminished. Courts in the US, Canada, and Australia previously took the view that the constitutionality of military justice depended on there being a substantive connection between the particular matter and the discipline of the armed forces. This approach has been abandoned in all three jurisdictions. The US Supreme Court in 1987, the Supreme Court in Canada in 2019, and the High Court in Australia in 2020 rejected the so-called service connection test and acknowledged the constitutionality of a military trial of any currently serving member of the armed forces for a civilian offense. What this means is that the relative significance of other factors that we are discussing in this talk, both formal and informal, grow in significance. Next, in terms of formal factors, national security may make a trial before a military tribunal the more viable option. In particular, when the matter relates to the conduct of military operations, there may be a need to present classified evidence. In a case before a military tribunal, ensuring that all participants hold appropriate security clearances may be far easier than in the case of a civilian court, especially where the trial is by jury. And finally, even where prosecutorial authorities retain discretion after the formal factors have been taken into account, the exercise of that discretion may be subject to prosecutorial guidelines or express agreements between military and civilian prosecutors. For example, in Australia, the Director of Military Prosecutions has signed a memorandum of understanding with the Federal Director of Public Prosecutions and the Directors of Public Prosecutions of each of the Australian states and territories. Among other things, this memorandum records a number of factors that the Director of Military Prosecutions must take into account when deciding whether to bring charges within the military justice system. And I will now turn the floor over to Alison to discuss some of the more informal factors involved.
Thanks very much, Ryan. So I now want to turn to the informal factors that may contribute to the decision whether to investigate or prosecute in a military justice system. I note that these are not an exhaustive list, and we would welcome your thoughts in this respect. The first factor is the seriousness of the offence. A military justice system, such as the Australian or indeed the Canadian system, has the capacity to hear cases involving the full range of offences. But if a serious offence is committed within the territorial jurisdiction, it would appear more likely that it is dealt with by the civilian justice system. In Australia, this is embodied within the Defence Force Discipline Act, which was discussed by John in his presentation, which provides that the prosecution of murder, manslaughter or bigamy and certain sexual offences in the military justice system requires the consent of the civilian Director of Public Prosecutions. Equally, the seriousness of the allegations of war crimes contained in the Brereton report as international crimes involving Australian Special Forces in Afghanistan also meant that the investigation by the Federal Police and prosecution through the Civilian Director of Military, for two reasons. First, to ensure that there was no question that Australia would fulfil its obligations under the Rome Statute of the International Criminal Court, given requirements of complementarity. And second, to ensure that defendants would be tried by a jury. While the military justice system can operate without a jury, despite the requirement for trial by a jury for indictable or serious offences in the Australian Constitution, there is clearly some discomfort about the possibility of a war crimes trial being held without a jury. Many would regard jury trial for a serious offence in Australia as a fundamental constitutional guarantee. This also raises the question of the public interest in a jury trial, and with that in mind, I will now turn to the second of the informal factors, and that is potential public interest factors. Now, in relation to public interest factors, the question is whether there is a public interest in a matter being heard in the civilian or a military justice system. Here I distinguish between the question whether the public or media is interested in a particular matter, arguably not relevant to determining whether an offence should be investigated and prosecuted in a particular system, and the concept of acting in the public interest, a phrase often used in a public law context. The notion of what is meant by the public interest is notoriously difficult to define, a point that has been articulated by both commentators and courts. For example, it has been suggested that it refers to community, common good, welfare, society, public, or the nation. It is sometimes used in contradiction to matters of a purely private interest, although it is noteworthy in the military justice context that the European Court of Human Rights has reiterated the principle that the public has an interest in ensuring that an individual's rights are protected. In determining an appropriate avenue for investigation and prosecution, the public interest could be said to include the need for open justice, which many would see as enhanced by civilian trials over military trials, even though courts martial may be held in public. In addition, as stated earlier, the public interest may be enhanced by ensuring that serious matters are heard before a jury, where a jury trial is available, to ensure parity between treatment of civilians and service members. In the case of the war crimes allegations against Australian Special Forces, and indeed where such offences have been alleged in other countries, there is also an implicit understanding that a state's national interests have been damaged by such allegations. This may lead to a perception, unwarranted, at least in this case, that the military will not appropriately investigate and prosecute its own. The public interest in relation to military justice could also include the effect on operational effectiveness and morale of the military. And here I draw on comments in a report that has already been referred to, and that tabled by Maurice Fish in the Canadian Parliament on the Canadian military justice system. Now, these factors could be argued on both sides of the equation. Is the morale of the military enhanced by having military personnel treated in the same way as other civilians when faced with serious offences, the citizens in uniform concept? Or is morale enhanced, as another speaker has suggested today, by having offences on operational service dealt with by those with an understanding of the unique characteristics of military life? The third factor is the most effective use of resources. Issues involving resources can include questions as to whether a military investigation and prosecution service is adequately resourced to deal with certain types of offences. For example, can it provide the necessary victim support, specifically in relation to sexual offences? Does it have adequate resources to investigate complex crimes? Resourcing issues were also mentioned briefly in the 2021 report on Canada's military justice system, on the basis that the Canadian Military Police Group orders provide a list of factors to be considered by military police when deciding whether to investigate a case, including the resources needed to investigate the complaint. Another resourcing type concern relates to the need for an investigation to take place wholly in the territory of the relevant defence force, or whether an investigation has to take place overseas. Additionally, if part of the proceedings need to be heard overseas because of witness availability, it may be that the deployability of a military justice system and its ability to hear cases outside a state's jurisdiction suggests that this is the more appropriate forum. Interestingly, in the Australian case, even though courts martial, as provided for in Australian law, can sit overseas, they seldom do so. There are several reasons. First, the security situation in places where the Defence Force is deployed is often not conducive to holding trials. Second, the time taken to investigate serious offences may mean that the accused has already been posted back to Australia by the time proceedings get to the trial stage. And I'll now hand back to Ryan for the conclusion.
In this talk, we hoped to demonstrate that the potential clash between military and civilian justice systems will be resolved by reference to a complex mix of formal and informal factors. The question may well arise whether this situation is appropriate. Indeed, the arrangements that we have described introduce a degree of uncertainty for the offender. We suggest that this is not as problematic as it may seem. For one, considering the complexities of military offences, it is difficult to come up with a hard and fast rule that would provide a solution in all instances. For example, our analysis of Australian practice suggests that the more serious the crime, the more likely it is to be tried in the civilian justice system. This is, we say, because the criminal dimension of such offences, such serious offences, is more significant than the disciplinary dimension. However, it would be very difficult to stipulate in the abstract that, for example, murder should only be prosecuted in the civilian system, whereas the causing of bodily injury in the military system. A degree of discretion afforded to prosecutors allows for a finer balancing of competing interests than a one-size-fits-all regulation. Second, we do not think that the uncertainty about the prospects of a military or civilian prosecution results in a serious injustice to the defendant. Service members must assume that their actions are governed by military and civilian law. Service members know, or at least ought to know, what kind of behavior is prohibited and punishable. Not knowing exactly which system will address their wrongdoing does not seem to offend against the principle of legality under criminal law. Having said this, we believe there is considerable merit in being upfront and explicit about the factors that prosecutors and investigators consider when allocating cases between military and civilian justice systems. Memoranda of understanding of the type concluded between the Australian prosecutorial authorities and made public can enhance transparency and accountability in decision-making. Thank you very much, and special thanks to the interpreters who are happy to take your questions and comments.
Merci pour cette présentation très complète et ces comparaisons entre les différents modèles. Voilà, l'heure est venue de passer aux questions-réponses. Est-ce que vous avez, nous avons une 15-20 minutes, une question pour l'un de nos 6 intervenants présents ici ou à distance en visio depuis l'Australie. Oui.
Thank you. I just wanted to ask a question. A few speakers asked about a perception of justice or a perception of independence and impartiality. And I was wondering, because this seems to have been sometimes, not always, but sometimes what's driven a change of jurisdiction or reforms according to the ECHR. And I was wondering what the speakers thought might be ways that military justice systems can improve the perception of justice, both actually for members of the armed forces, because I think it's important they believe that it's legitimate, but also for members of the public, which seems to drive a lot of the reforms as well, if the public perceive it. So sort of structural things aside, are there specific perception elements that might be done? Thank you.
Merci.
I think perception is very important, and you're right to stress the fact that it's important for the serving personnel as well as for the public. I think it's very important that, firstly, any military justice is done publicly. The courts that we have in Britain, we have 2 military court centres. They were built about 10 years ago. They're built on the wire, if you like, on the military fence. So there is public access, and there's military access from the barracks that we happen to be adjoined to. So there has to be public access, there has to be press access, so that all cases can be reported. I think the other thing that comes to mind for me is that the justice system has to be properly fit for purpose, and so every part of it has to be professional. And so your police force, we have a military police force in each service, Army, Air Force, Navy. They have to be professional. We have a special investigation branch in each of those services. They have to be particularly trained. Your prosecutors have to be, again, professional and capable. And your judges, we have to be professional and capable as well. And if that system is then subject to appellate scrutiny, as ours is by the Court-Martial Appeal Court, but in fact the Court-Martial Appeal Court is our criminal division appeal court as well. It's the same place, it's the same judges. Then there is that appellate scrutiny as well. And if you put all that together, then you can stand up, as I do, and say that the British military justice system is fit for purpose. But if you're lacking some of those elements, I think you're in a bit of trouble.
Thank you.
Could I just add there to what His Honour said? It's interesting that sometimes there is a perception that perhaps sometimes people in military tribunals aren't getting a fair go, as we say in Australia. Within our military justice system, because we've maintained the British model, every conviction of a service person goes to automatic review, and that review is done by a senior officer who is bound by the advice of a legal officer who provides a legal opinion. If the senior officer isn't happy with the advice given by the legal officer, he can seek a second opinion from the Judge Advocate General, who is a Supreme Court judge. So that's an automatic review. In addition, the member has rights of petition and review. So under our system, there are actually more rights of review and petition and appeal than are given to a person convicted in a civilian court, and those rights are automatic. There's no need to apply for leave. There's no need to show a substantial miscarriage of justice. The automatic review occurs and the petition right remains open all the way to the head of service and ultimately Chief of Defence Force. So I agree with the question, though, that the perception becomes reality after a while. And for the reasons His Honour's identified, I think it's important that it be open and transparent.
Monsieur le Procureur Général.
Merci. Thank you. In my presentation, I did evaluate on this very interesting question that was posed, the perception issue. And of course, I fully agree with my esteemed British colleague that transparency is essential. We have an open court justice system. The court publishes lists on the case pending, and I can tell you that the press is really present every time we have a high-profile military case. So transparency, what does the system consist of, the elements? And actually, as I mentioned, we are very focused on also being transparent. We have a lot of requests from journalists to dig into our cases, and if it's safe for the parties in the case, the defendant and the witnesses and so on, we would give as much information as possible to have the right description of the case. So we don't see these types of media coverage that would give let's say, a totally scrambled view. The other part I did something about in my presentation was what my colleague from Britain also mentioned, and that's the professionalism. I said that the quality of the products are, of course, essential. If we are not good enough, if the staff is, let's say, the investigators, they are not good enough, or the prosecutors, then we would face issues, and I can tell you we would not be in existence that much longer. So that is some of our focus areas. Yes, I believe that would be an answer. Thank you.
Merci. Votre question est centrale puisqu'elle touche aux aspects organisationnels, aux principes de fonctionnement, mais également aux principes, l'application des principes de fond. Et peut-être que le professeur Duxbury veut également réagir à son tour. Je ne sais pas si elle a eu la traduction. Est-ce qu'il y a d'autres questions?
I just want to make a question to Mr. Alan Larch. And this question has some connection with this one that you have made. What is your perception about the fact that the United Kingdom has civilian courts to judge military crimes? For me and for us, the speaking Portuguese countries, this is something like new. Do you think this is a good solution, or do you think that you have some problems, some troubles, sometimes in some cases? What is your opinion, and what is the perception of the military people about this?
Could you just explain a little bit more? Military crimes in the United Kingdom are tried in a military court.
But you told that you have civilians judging or not?
No, civilian judges, but
yes.
The jury is made up of military personnel. So they are officers and non-commissioned officers, and they are the jury in the court-martial. So it'll be me as a judge.
Yes.
I'm a civilian. I work for the Ministry of Justice.
Okay, yeah.
So I'm independent.
Yes.
But the jury, 3 or 5 or up to 7, are service personnel, serving military personnel.
Okay.
So we have a very military tribunal with an independent prosecutor and an independent judiciary.
Yes, okay, I understand. It's almost the same as Portugal.
I think so.
Yes, okay, thank you.
I have one question which perhaps our Australian friends might deal with, please. And I know Canada have considered this. The factors you have described, your formal and informal factors, do not include, as I understand it, the wishes of the defendant, his rights to a trial in a jury perhaps, and the wishes of the complainant, the victim, as to what he or she might want and where they might want the case to be heard. How relevant are they, do you think?
Thank you very much, Your Honour. I will start with that and perhaps hand over to Ryan. I would say that our presentation was slightly longer, and we did actually include issues relating to the complainant's wishes and how that might be a relevant informal factor. Although we didn't necessarily look at the defendant's wishes, which may be either a formal or an informal factor, of course, depending on the system and depending whether you're talking about a minor or a more serious criminal offence. But yes, I acknowledge the relevance of those, and we did have them, and then we zapped them out for a 20-minute presentation. But Ryan might have something to add there.
I don't have much to add other than to say that in practice in Australia, the victim's wishes do seem to play quite a significant role. So the investigative authorities that the victim turns to tend to have a first go at dealing with the offence. And often the complainant actually prefers a trial in the military justice system or prefers the military authorities to deal with the matter. And that is a consideration that is listed in the Australian Director of Military Prosecutions prosecutorial guidelines and the MOU with the civilian prosecutors.
Avez-vous d'autres questions? Oui, monsieur.
Hello, my name is Brian Cox. I'm a retired U.S. Army judge advocate and current doctoral candidate lecturer at Cornell Law School. Thank you all very much for your most insightful and intriguing presentations. I have a question that actually kind of runs along the same line as the previous question, but kind of looking at it from the flip side of the coin. One of the consistent themes that runs really throughout all presentations is a concern of potential unfairness and bias that runs systemically throughout military justice systems. And I wonder if there's a sentiment in any of your jurisdictions specifically, or just kind of in general public discourse, that we should endeavor to objectively measure whether there's a bias and lack of independence that actually exists in order to inform our policy and procedural reform measures, or is just the perception becomes reality and the perception of unfairness, is that typically considered to be enough to be sufficient to drive military justice reform decisions? Thank you.
It would be very good to be able to measure bias. I'd welcome your suggestions as to how we might do it.
Might I offer one?
Please.
There was a study that was conducted over about a 3-year period in the United States. As you may know, I'm sure that you're aware, over the last decade or so, there's been a concern that commanders lack sufficient impartiality when deciding whether to send allegations of sexual assault to court-martial. And so over about a 3-year period, there was a panel that was formed to study actual case files that were considered by commanders. So they divided the case files into 2 separate tranches, and it was judicial prosecution and judicial experts who evaluated kind of ex post the decisions, the evidence that was presented to the commanders when they made their decisions. And so it was a case-by-case analysis and evaluation of those decisions. And this panel determined that there is not a systemic concern with bias in terms of decisions that military commanders are making. And they found that between the 2 separate piles, I guess, of case files, that 95% and 98.5% respectively, those decisions were reasonable. And so it's a very, very extensive study that was performed over a period of several years to measure whether there is bias. But it was, I'm sure it was incredibly expensive and incredibly time-consuming. But in the end, I think it was actually really informing.
And that was in relation to the decision to bring charges?
Yes, sir.
So there was a paperwork review available. It's much more difficult, I think, to review whether there's bias in the tribunal that makes the decision of guilt or innocence, which is what I think there's some focus on, and whether a military tribunal made up of military judges, as ours is, has an inherent bias or an appearance of bias. And that, I think, is almost impossible to measure. So one has to look at appearances.
Sorry, so as not to monopolize the floor, but one potential possibility would be to examine decisions both on motions and judicial final decisions on guilt and innocence or sentencing in the civilian context on similar case files, and measure whether judges in the military context make similar decisions or if they tend to be biased one way or the other.
Bonne chance, monsieur. I think one jury in one court, in a Crown Court in England, may make one decision, and another jury on the same facts may make a different decision. It would be an interesting study, and I look forward to reading it when you finished it.
Thanks. I'll just talk to Congress and see if I can get funding for it.
Nous avons épuisé les questions, mais pas l'auditoire, j'espère.
Si je puis me permettre une petite remarque.
Oui,
je voulais simplement remercier nos intervenants de ce matin pour leur brillante communication et les remercier aussi d'avoir parfaitement répondu aussi à l'appel à communication de ce forum. Vous avez chacun et chacune présenté donc, les différents systèmes de justice militaire nationaux, leurs grands traits saillants, leurs évolutions. Vous avez aussi rendu compte de leur diversité, de la diversité des systèmes de justice militaire dans le monde, avec des systèmes qui sont plus ou moins civilianisés, plus ou moins judiciarisés. On voit aussi qu'il existe des groupes, bien évidemment, alors ça ne surprendra personne, mais il y a tout de même une famille, la famille de tradition anglaise, avec un socle commun qui est le modèle anglais, qui a pu ensuite être adapté aux États-Unis, en Australie ou au Canada. Et puis, au sein, au contraire, d'un autre groupe qu'on aurait pu croire un peu plus homogène, la famille plutôt de tradition dite portugaise ou d'ancienne tradition portugaise. Au contraire, l'Angola et le Brésil n'ont pas suivi la voie empruntée par le Portugal. Donc c'est assez intéressant de voir que dans des zones géographiques, les évolutions de la justice militaire ont pu être différentes. Voilà, je terminerai par cela mes commentaires et je garde tous mes commentaires pour la fin de la journée. Merci beaucoup.
Merci Gwenaël. Merci donc à nos 6 intervenants. On fait une pause méridienne et nous reprenons les travaux cet après-midi, donc à compter de 14h dans cette même salle.
Petit quoi voilà, je t'aime. Ah non, mais il ne faut pas oublier la nation de...